Good afternoon, good evening, good morning to everyone dialed in. I'll introduce our panel shortly, but by way of a very brief introduction from me, I'm Tim Lees. I'm a partner in the restructuring and solvency team at Clifford Chance in London, and I spearhead Clifford Chance's thinking on crypto and distress globally. If I may, I'd like to cast everyone's memories back to the start of crypto winter, as it's called. So crypto winter began with the Terra Luna collapse in May 2022, which led to a series of high-profile insolvencies and something of a chain reaction. The price of BTC in dollar terms, used as a benchmark of market sentiment, fell by approximately 75% between its peak in November 2021 and November 2022, and over 60% after May 2022. Right now, we're in something more like crypto spring, with BTC and ETH now trading at all-time highs and renewed interest in altcoins. So now is a good time to reflect on the lessons learned from the last downward cycle and to think about how things could be improved for the future. And it seems to us that that's an important thing to do. The aggregate value of all cryptocurrencies is circa $2.9 trillion, according to Forbes as of this morning, with Bitcoin making up approximately half of that. And there are over 100 currencies with a market cap of over $1 billion. And whilst the future is uncertain, with the launch of digital asset-backed ETFs, growing interest in central bank digital currencies, and in light of the ongoing use and development of digital assets more broadly, it seems a reasonably safe prediction that we'll see an increasing use of cryptocurrencies and other forms of digital assets as a store of wealth, as a way to fund new ideas, and increasingly to solve real-world problems. So to help us unpick some of these issues, I'm pleased to introduce you to our esteemed panel. We have Christopher Farmer, a Senior Managing Director with Teneo in the BVI, and a founding member and global head of Teneo's financial advisory, digital assets and blockchain team. Chris has and continues to act on some of the highest profile BVI and solvency appointments of recent years. Most notably, he's one of the joint liquidators of Three Arrows Capital Limited in liquidation. Next, we have Professor Louise Gullifer, KC, who is the Rouse Ball Professor of English Law at the University of Cambridge and a Fellow of Gonville and Caius College, Cambridge. She was the UK delegate to UNTRAL Working Group 6 during its work on secure transactions, and is a member of several UNIDRAFT working groups, including chairing the drafting for the principles on digital assets and private law. She currently co-directs a project on digital assets and has worked with the Law Commission of England and Wales and the UK Law Tech panel in their projects in this area. And last of all, we have Donna Wacker, who is a partner at Clifford Chance, where she is co-head of the Asia Pacific Regulatory Group and head of contentious insolvency in Hong Kong. Among other roles, she's advised the liquidators of Gatecoin since its entry into liquidation in Hong Kong in 2019, including in relation to the landmark decision of the Hong Kong court, which held that, as a matter of Hong Kong law, cryptocurrencies are property capable of distribution to creditors or beneficiaries, which considered the nature of the platform's terms and conditions, something we'll return to during this session. So, Chris, if I may start, Three Arrows Capital was the first high-profile insolvency of crypto winter. Can you talk a little bit about how Three Arrows ended up in insolvency proceedings and how you came to be appointed? What were the issues you had to grapple with as an office holder on day one?
Yeah, thanks, Tim. So for those who don't know, just to give a bit of background, 3AC was a BVI incorporated regulated entity that operated as a crypto hedge fund, operations primarily in Singapore, but with globally facing counterparties. Teaching everyone to suck eggs, but a hedge fund effectively is a pooled investment vehicle, holds liquid assets that make use of complex trading programs, algorithms, risk management techniques, etc., to ultimately improve investment performance and to beef out the returns for participants. Common techniques or portfolio techniques include the use of short selling and leverage, derivative products, instruments, etc. So the fund in this case operated via a common master feeder structure. There were offshore feeder in the BVI, an offshore feeder in an onshore feeder in the US, operating through the master fund, which was 3AC, heavily invested into Web3, and by that I mean crypto and other related ventures. The 3AC itself was primarily funded through large non-retail investors, and leveraged through additional crypto borrowings, and that's really where one of the first issues arose for 3AC in terms of its solvency, because as we've discussed and as you touched on there, the peak of the crypto cycle was a roughly $3 trillion in terms of global value in November of 21, and what followed was quite an astonishing drop in the value of crypto that was driven by a number of both macro and crypto micro factors. So looking globally, there was increase in the interest rates. If we're looking in terms of specifically to crypto, there were a number of hacks. There were rug pulls. Rug pull is effectively a type of fraud that's instigated in terms of initial coin offerings. There were ongoing regulatory and political concerns, with a lot of focus being upon crypto. So it reached its nadir of around 850 million in June, July of 2022. That contagion from the general market fallout directly impacted 3AC, given its highly leveraged position and operating model. And now you have to bear in mind that a lot of the borrowing that was undertaken was in crypto, and a lot of the lending that was then put out by 3AC was also in crypto. So the collateralized loans were held in a basket of cryptocurrency, not necessarily just one form. So, for example, not every loan was backed or collateralized by BTC. And as we've seen with the crypto winter, as you put it earlier, whilst crypto tends to take stairs on the way up, it certainly takes the elevator on the way down, and that's caused significant issues for the liquidity of 3AC at the point of its collapse, given the drying of liquidity in the market post the Terra Luna collapse.
I was on mute. Chris, one of the questions you had to work through was where you were going to file. How do we end up in the BVIs rather than other jurisdictions which it could have worked with?
Yeah, so I mean, it was a BVI incorporated entity. Then it was regulated by the FSC and the BVI, so it was fairly simple in terms of jurisdiction. Ultimately, the company itself petitioned for its own winding up, which made it that much easier for the court to find that jurisdiction fell within the BVI. Also, went to the point of the company having to prove insolvency when the company is seeking to wind itself up. It's inherent, it's always implicit rather that the company is in an insolvent state. So there really was no issue from a jurisdictional perspective. Now, that's not to say that since we've been appointed, there haven't been issues that have arisen given the global nature of the crypto hedge fund business. I mean, crypto itself is Web3 technology is by in of itself decentralized, but counterparties are or have residency in a number of different jurisdictions, and you're looking at large counterparties in the US and Singapore, etc., and across multiple jurisdictions, really.
One of my favorite situations, we tried to work out where the Comey of a crypto platform was the center of main interests, and the CEO was living on a yacht in the Caribbean, and the CFO was living on a yacht sailing around the South Pacific, and trying to work out which jurisdiction that really points to, is challenging. Yeah. So as you say, you end up with the jurisdiction of incorporation, and which is not necessarily the way that international insolvency was pointing prior to this set of developments. What about getting cooperation from the founders? Because obviously the company itself filed, as you point out, but the human element of this is also really important. Could you talk a little bit to that and how that played out?
Yeah, so as you said, the fact that the founders filed for, when I use the founders, I mean Carl Davis and Zhu Zhu, who were the two founders of 3AC. The fact that they as directors filed for the liquidation of the company, we thought that would mean that there'd be cooperation would be forthcoming. It has been well reported that isn't the case. There have been a number of different applications that have had to be brought by the liquidators across different jurisdictions to effectively enforce cooperation or to seek cooperation from the founders to assist us in fulfilling our duty. So our primary duty is there to protect and realize the company, the assets of the company, and to make distributions to creditors. And we're dealing with crypto here, so dealing with a hugely volatile asset. Tim, you touched on this earlier. We're looking at 850 million back in 2022 to now it's in almost 3 trillion by the first opening months of 24. It's, the volatility in the market is astonishing. And for an insolvency practitioner where we're trying to effectively get hold of, protect and secure assets of the company, the cooperation of those who have been involved in the day-to-day operations is critical. We would have expected them, if not to approach us with open arms, and certainly to have been much more active in terms of providing information to us than they have been. But as has been well documented, that's not unfortunately been the case.
Donna, Three Arrows Capital was obviously a milestone moment in the development of crypto, certainly in the Western world. You've been advising the liquidators to Gatecoin in Hong Kong since 2019. So what do you think was different than the wider crypto winter insolvencies, and what's been the same?
Yeah, good question. Actually, a lot of what I just heard from Chris is relatively, there's similar, obviously similarities in terms of what the liquidators had to come in and do, and dealing with the various stakeholders and trying to realize a very volatile asset. But the interesting thing is that Gatecoin, this company went into liquidation when the market was low. So it wasn't a question of sort of the volatility having been the thing that sort of caused the issues. In fact, what happened was, this was a company, for those who aren't aware, it was one of the, I think it might have been the first crypto platform in Hong Kong. And it catered sort of professional traders, retail investors from all around the world, kicking off in sort of 2015. And it allowed people to sort of deposit and trade 45 different types of crypto. It's quite a lot considering this is the really early days. And in addition to taking deposits from customers, Gatecoin itself was also had its crypto on the platform and was trading with the customers as well. So, and what happened was, it actually suffered a cyber attack in May 2016. If you remember, at that point, there was a number of years where there just seemed to be a different cyber attack, like every quarter. There was so many of them. And unfortunately that happened, and the hackers stole, it was around 2 million US worth of BTC and Ethereum. And that represented around 15% of Gatecoin's total assets at the time. And I mean, talking about volatility, at that point, as I said, $2 million, I think in current terms, it was about 60 million. Like, it's gone up that much. So when the company went into liquidation in 2019, that 2 million that had been stolen was worth 26 million. So as I said, that's sort of the interesting thing, is this happened. And the reason it happened was actually not even the hack, which a lot of people, I think, at first blush thought that was the cause. I mean, it didn't help, right? A lot of customers got the heebie-jeebies and pulled out. But it was actually the sort of cryptophobia, as it was called at the time, of some of the banks in Asia cracking down on crypto platforms. And there was some sweeping sort of money laundering reforms coming in. And Gatecoin found itself with all its bank accounts frozen. This is in around 2018. So they had to then go and look elsewhere for a service provider to help them with payments. And they actually went to they did the right thing. They went and they found a regulated European payment processor. But unfortunately, they failed to sort of be able to process transfers in a timely manner. There were lots of issues, and essentially the platform was sort of paralyzed, and operations suffered, and they suffered a lot of loss. And we helped them in the early days to actually recover funds from that European service provider in France and get a little bit of money back. But it was actually that sort of whole scenario that really brought the company down. It was wound up then in early 2019. And similar, I guess, to what Chris said, this was a Hong Kong company. The platform was in Hong Kong. The individual running the platform at the time was in Hong Kong. So there were no issues there with jurisdiction. It was naturally sort of Hong Kong was the correct forum for that company to be wound up. Yeah.
Louise, change deck a little bit. I think it's probably fair to say that you saw some of these issues coming. Well, a number of us saw these issues coming, but you were, of course, especially prescient. You've been working on digital assets and private law questions for some time, ahead of Digital Winter. Could you talk a bit about some of the work you've been doing, perhaps in particular with UniDroit?
Yes, sure. So the first time I sort of got involved in all of this was in about 2018, when I spoke at a conference and wrote a paper about digital assets and crypto assets and insolvency, and particularly talking about what we call custody and so on. So it's really been something that I've been thinking about for some time, partly as a result of that and partly because there was general discussion at UniDroit about the fact that lots of legal systems have been sort of grappling with all these difficult questions. That's when the UniDroit project started, and in about 2019. So we're going back a bit. It's now come to its conclusion. I should explain perhaps for our listeners, if they don't know what UniDroit is. UniDroit is an intergovernmental organization that produces private law international instruments. So it could be treaties, which is hard law, it could be model law, soft law principles, which is what we've got on digital assets. And the thought was that there were a number of sort of very basic questions that legal systems weren't quite sure either what the answer was or what the answer should be, or how they would justify it within their own legal system. And the whole idea of the UniDroit principles is to try and tackle some of these really basic issues, to give guidance to states without interfering effectively with the state's private law systems, because we tried to do it in such a way that they could be incorporated within anybody's private law system. I should say, and I'm going to give one or two examples of this, that quite a lot of states' law, sort of as it were, is consistent with the UniDroit principles. I mean, they are obviously don't come from nowhere. They come from many states representatives who have been involved in formulating them, and it's quite interesting to see that quite a lot of what we said is now sort of panning out, particularly in these insolvency cases, and you can see that they're taking the approach that the UniDroit principles suggest. So the kind of questions we were looking at were things like, what are digital assets? Can they be the subject of proprietary rights? Are they property, is what we'd say in the common law, but we have to phrase it like that for other jurisdictions. How do you transfer them? How do you take security over them? Custody, what do we mean by holding a digital asset? What are the ways that they can be held? And one of the most important areas is on insolvency. And on insolvency in particular, we started off by defining digital assets in such a way that everybody in the project was happy. That meant we could then say digital assets can be the subject of proprietary rights. And we've had a lot of cases, particularly in the common law world, getting to that conclusion for more or less the same reasons that we came across. But we wanted to make a very clear statement of that, so that could be the basis of national law pretty much anywhere in the world, because we think that's a good start. And once you get to that stage, then you are in a position to say, well, those proprietary rights can survive insolvency, when the insolvency of the direct owner, and it will also survive the insolvency of a custodian when the assets are held in custody, which is what we've basically been talking about. And the way that we defined custody is in a very functional way. We don't say that any particular system is better than any other. But as we know in common law systems, the analysis we would normally use is to say the custodian holds the assets on trust for the clients, which is the analysis that was used before for intermediate securities, for example. And that, of course, gives the clients protection on insolvency. Now, there are lots of problematic issues as to how you know whether something is a custody situation or, for example, a situation where the intermediary actually owns the digital assets. That was an area that had to be looked at in the Celsius case. Celsius did a lot of crypto lending, and in their loan accounts, it was relatively straightforward for the bankruptcy court in New York to say, well, this is a situation where the intermediary actually owns the digital assets. And we tried in the UniDroit principles to define the line between that situation and the situation of custody. And we made a few other recommendations they're quite high level. I mean, obviously, any jurisdiction is going to have to work out the details for themselves. But one of the recommendations, for example, is that where you have a pooled account, where the shortfall is that the distribution should be pari passu. And I was interested to see that was the conclusion that was reached by the judge in the latest Cryptopia decision, which was handed down on the 1st of March in relation to the assets that were distributed from the Cryptopia insolvency in New Zealand. And the judge said, well, there are other ways of dealing with trust assets, such as Clayton's case, first in, first out, effectively. But, where it is uneconomic or just impossible to apply that, then you can use pari passu, and that's what they did. So it's those sorts of areas, I think, where the law will be developing and is developing within case law in a sensible way. Sorry, Tim.
No, well, I thought you were just wrapping up, but okay, no, that's really interesting, Louise. Chris, maybe change tack again, right? Just coming back into the 3 Arrows liquidation. The cross-border aspects of that, as we've sort of started to touch on already, have been very, very important. And we've heard from Louise how individual national legal systems have had to work this out, and how it's played out slightly differently, albeit with a lot of similarities between the Gatecoin and 3 Arrows cases. But let's just drill down into that cross-border recognition, cross-border insolvency issue a little bit more. Could you talk a bit about the issues that have come up on 3 Arrows, the steps that you've taken, and what you think could be better in future?
Yeah, so I mean, we touched on this earlier that the placement incorporation as BVI Cayman was found to be the BVI operations globally. So crypto is analogous to TradFi in a sense that it is a global market. It operates across a global market. Now, whilst we talk about decentralization in terms of crypto and Web3 products, that's effectively getting in respect of the protocols themselves. Now, there are a number of counterparties that we have to deal with as part of a liquidation estate that have legal personalities. Not every crypto protocol is run by a DAO, which is a decentralized autonomous organization. But even DAOs have legal wrappers, or a lot of DAOs have legal wrappers. There are vehicles that are set up specifically in places like Cayman and BVI through foundation companies or limited liability companies to act as effectively that legal wrapper for these decentralized autonomous organizations. So we're dealing with not just counterparties that exist, as legal personalities within the global crypto market, but also, as we said, these decentralized autonomous organizations that effectively live either through their local personality via a wrapper, or they are simply just living within the ether, running via governance protocols, etc. So faced with that, we're looking at where the majority of the assets, and this goes back to the primary duty of the liquidator to protect and secure the value of the assets. The second pillar is always distribution, and distribution can't be achieved without obviously the first step of securing those assets. So we're looking at where are the assets based. So the recognition, the primary or the main proceeding is in the BVI. We then got Chapter 15 recognition in the US. That was important because that promotes cooperation between the US courts and the parties our interest with the either foreign court within the US jurisdiction and cross-border cases. So we applied for interim relief in the interim and then leading to full relief. So that effectively gave recognition in the US of our proceedings, gave access to the judicial proceedings by us as the foreign representatives as a foreign main proceeding. So we get, for example, a moratorium, which acts as an automatic stay in the US. We've already touched on a point. There are a number of assets and counterparties that were held in the US, so we could issue subpoenas for seek discovery, etc. We ran exactly the same playbook in Singapore. Pretty much, it's almost the same application, just under the Singaporean bankruptcy law. The other jurisdictions which we've had to grapple with in terms of recognition, we've sought recognition in Cayman again because a lot of crypto funds and counterparties are registered or incorporated in Cayman Islands. Seychelles is a huge jurisdiction for the setting up, especially of crypto exchanges, so for the purposes of getting disclosure relating to the tracing of crypto assets, and that's very, again, to enable a liquidator to protect and secure and then make distributions for on-chain forensic tracing is incredibly important. A number of tools, and there's a lot of jurisprudence out there now in terms of applications against parties unknown and anti-pillar orders and bankers' trust, etc., to seek discovery. But within a liquidation sense, it's much easier for us simply just to seek recognition and utilise the powers that are available to us in said jurisdiction, although NPOs can still be utilised, or Norwich Farm Courts can still be utilised where that may not be, cost efficient or possible. We also have in 3AC in December of 22, we got an order at the BVI Court, which was effectively allowing for cooperation between the US, Singapore, and at that time BVI Court, based upon the GIM protocols. So this is really a court-to-court cooperation protocol to allow the courts to communicate openly, especially where we're dealing with, again, we're dealing with points of law, as Louise touched on earlier, that are being debated globally and may not yet have been fully formalised, albeit crypto as property and therefore forms part of an asset of the estate, I think is now settled for the jurisprudence. But there's different aspects in terms of where is the property actually being, or the crypto being controlled or maintained from, knowledge and control of the private key, etc. So there are all these issues that need to be addressed or have to be addressed as part of the process, and it allows the court to have that open line of communication. It's all about trying to make the process as efficient as possible. I mean, there's a lot to be said for keeping the courts updated as to the ongoing liquidation. So for example, we regularly file reports with the BVI Court, but we do that, if we're doing that in 6 jurisdictions, that can become somewhat overwhelming. So it's easier to allow the communication to occur almost organically between the court based upon the GIM protocol.
The GIN protocol is the Judicial Insolvency Network protocol, for those that may not be familiar with it. So it's a grouping of the judiciaries, actually, of a number of key countries around the world, including the US, Singapore, England, and many others besides, which again has been very useful to you clearly in this situation.
Yeah, and look, if anybody's got an interest in reading it, the order is up on our website. So we maintain a 3AC liquidation website that's publicly available, and there's a copy of the order on there from the BVI Court, if that's of interest to anybody. Touching on that as well, and it's actually quite a nice segue into the sort of public nature of as you said, some of the issues that we'd struggled with on 3AC. So as we said earlier, the cooperation of the founders was lacking. We've had, whilst we could obtain orders from the BVI Court and for the BVI Court, the Singaporean Court, and the US Court for examination and to compel those persons to attend for examination, there are always issues with service. So especially in order with the BVI Court, for example, where the directors aren't within the jurisdictions, we then have to get service out of the jurisdiction, and then we're looking at, well, how do we actually serve them if we don't know where they are? So there's one of the paths that we followed on this case, and has been sort of very publicly reported, was obtaining alternative service via the use of posting the orders on Twitter, which is now X. So we sort of pioneered the use of or sought the first orders from the US courts in terms of individuals, not corporate entities, and the posting of the orders on Twitter. We were only able to do that simply because the founders who had gone dark post the appointment then came back into the light, as it were, and started posting regularly on Twitter or X. So they sort of made a rod for their own back there, but allowed us to at least access them and put those orders. And again, 3AC has a Twitter handle that you can look up and see all of the orders that we've put onto our Twitter sphere. There are other sort of leading into the Web3 technology in and of itself. I mean, we've used, for example, non-fungible tokens. So the difference between 2 types of tokens, effectively fungible, which is Bitcoin, Ethereum, sort of well-known tokens, fungible when they can be replaced with any other type of coin or token, and then non-fungible, which effectively have individual characteristics. So non-fungible tokens, everyone knows the concept of an NFT, for example, a picture of a Bored Ape Yacht Club. NFTs are simply just wrappers. They're wrappers that allow you to utilize different standards depending on which blockchain you're operating on, and to build a token you can then input metadata into. So we've used NFTs as a way of giving notice to addresses where, for example, we don't know the owner of said address, because obviously addresses on a blockchain are pseudo-anonymous, so they're alphanumeric strings of letters or numbers. There's not, unless they've been what's referred to as doxed or tagged, there isn't this is a Mr. X's account, address or account. And therefore, but there is, given the nature of blockchain technology, it is immutable, but it is also transparent. There is nothing to stop you from sending somebody an NFT to their address. So we've used NFT airdrops, which effectively means we've been building NFTs, inserting notices of our appointment, inserting other documents into into the NFTs and then posting or sending that, transferring that NFT to the address of the recipient who we're now interested in. There was a recent case in the BVI, which is the AQF case, where the BVI has now for the first time approved on an ex parte order for service by alternative means the use of an NFT airdrop. So we've gone beyond just posting of NFTs for notice, and the BVI court has now sanctioned the use of it for alternative service.
I've now got an image in my mind of a Bored Ape Yacht Club ape handing a notice out to somebody saying you've been served. Probably not as exciting as that in practice. But look, something that Chris touched on there was the role of a liquidator. The purpose of a liquidation is to get in and realise the assets of the company, pay a distribution to the persons entitled. And in Gatecoin, the liquidators went to court to go and seek directions in relation to issues that really related to those core functions. Could you give some colour on what the issues were and what it is that the court directed?
Yeah, sure. Although it's not as sexy, as exciting as NFTs to serve people, I think we might have to take that offline, Chris. I'm curious as to whether you can use that to actually notify potential creditors of claims, because sometimes we've had trouble where you can't actually identify who is the actual creditor, because back then, at least for ours, there were a lot of people just had nicknames and whatnot and no proper identification. So to the extent it's trust property, it'll end up with the court because we can't get it back to the people who deserve to get it back. So interesting. So in ours, yeah, I mean, it touches on some of the issues that Louise mentioned. So some of this stuff might seem very obvious to people now, but at the time when we first sort of took over this in 2019, it wasn't as obvious as to two questions really, which is is cryptocurrency property under Hong Kong law? There was no decided law. It was not long after that the Cryptopia case that Louise mentioned, the first case was handed down. So that was incredibly helpful for us because there was a lot of similarity between the two cases. So we relied quite heavily on that case when we went to the Hong Kong court. And we also relied quite heavily on there was a legal statement on crypto and smart contracts that was published by the UK Jurisdiction Task Force at the time. And we adopted some of the reasoning in there as well to argue to the Hong Kong court that it should find that cryptocurrency is property, because there was a lot of literature about, well, some people were saying, look, it's just a cryptographic code. It might not be property. It could be just security or currency or something else. There wasn't a lot of consensus, but now I think it's quite established in England, Wales, Singapore, Australia, New Zealand, that it is property because it's definable. You've got your public key. The court said, yeah, you've got a public key allocated to a particular cryptocurrency wallet that's readily identifiable and distinct. So it has that nature of being definable property. It's identifiable by third parties, again, because you can the holder of that key, of course, can access and transfer the crypto from one wallet to another. So it's something that's capable of assumption, it's capable of trading, and it has that permanency because its life history is recorded on the blockchain. So there is some degree of permanence and stability, at least maybe not to the price, not a lot of stability in the price, but there's stability in terms of what it is we're talking about. So the court quite readily said, yep, it's property. The more interesting question in Gatecoin was whether or not what the liquidators were sitting on belonged to the estate of Gatecoin or whether it was held on trust for the customers. So the court said, yes, it's property, it can be held on trust. And they found that, again, for similar reasons to why they said it's property, there's certainty of the object. And it really came down to the intention. Was there an intention in this case to create a trust? And we had this quite crazy situation where there were multiple terms and conditions consecutive terms and conditions throughout the life of the platform, which is not uncommon, but ours range from sort of weird and wonderful things that seem to rely upon French law, even though it was a Hong Kong law document in the first instance. It didn't talk about trust at all. The second set of T's and C's that superseded that, which did talk very clearly about trust and used all that language that you would expect to see around sort of fiduciary obligations, all that sort of stuff. And then we had a third set of terms and conditions, which superseded the terms and conditions containing that trust language and said very clearly, there is no trust. We disclaim all fiduciary obligations. Anyone, who accesses this, the asset's not yours, etc. So it was very clearly disclaiming a trust. So it was quite interesting. So we went to court on that, and the court agreed with the liquidators that the first two terms and conditions, so the first one, which didn't mention trust, we argued, or the liquidators argued, that it was a trust because there was contemporary evidence that the company did intend to hold it. So we sort of had to go and find the lawyers who helped to draft the terms and conditions, and we actually got emails from them where they were communicating with the company and asking the company this exact question, and the company's answer was, well, of course the assets belong to the customers, they're not our assets. So there was some helpful contemporaneous notes that showed that actually it was meant to be a trust. But the court found, against sort of what the liquidators actually, if you read the case, liquidators' position was that actually when the third set of conditions came in, there was no evidence of any notification being given to customers to say that the trust has been disclaimed, and we thought that actually taking away a trust is a pretty material thing to do, and that there should be something giving people notice. The court said no. The court said, look, the contract said that when you click upon the website, by doing that you accept the terms and conditions, and the court said we can't ignore that contractual bargain that was reached between the parties, and when you click to accept, you're bound by these new terms, even if that meant you were being deprived of your property. So I think it was a good sort of warning, I think, to people, especially, I mean, I do it myself. I click on things on my phone saying, yeah, I accept the T's and C's, and I didn't read them. So I think I shouldn't admit to that. But, we all do it, I think, and we all need to be more careful. And interestingly, a lot of people sort of took away from Gatecoin that there was no trust, but actually the court said that, if those people who signed up for the platform before the T's and C's that removed the trust, if they signed up before then, but then didn't click on that third set, they do have a trust over whatever was in their account at the time. And so the liquidators we've spent the last number of months now trying to identify those people who actually hadn't clicked and do at least appear to have a trust. So it's really interesting. So I'm sort of waffling a bit now, but I find this really interesting. But what we've done is reached out to all these people and said, look, we think you may have a trust, or we've told people we think you don't, but please give us evidence if you think you do. And the interesting thing that's come out of it, which is I've got here on my desk the next list of questions for the court, which will be heard later on this year in Hong Kong, is there are a number of contracts, like, crypto mining contracts, certain trade, spot trades and things where someone puts on the order or puts on, agrees to this contract long before the last set of terms and conditions. And so when the crypto from that agreement or that trade went into their account, it happened sort of automatically, in inverted commas. The individual themselves didn't actually click. So there's this other interesting sort of questions we have to put before the court to say, on the logic of the first decision, these people should still have a trust. So it's really interesting. It's a shame. It's taking a long time because, obviously there's so many customers. I think that's part of the frustration with this sort of asset is that, you know, even that Cryptopia case, right, that's been years now since the first decision of the court, and that's how long I think it takes to undertake these liquidations and try to trace assets and try to find the creditors, and then try to work out, in our case, some assets will be given back in specie, I believe. That's also subject to the next hearing. But sometimes some of this crypto, as I said, there were 45 different types of crypto. Some of them are gone. Some of them are just worth almost nothing. So it's not cost effective to even return them in specie. So we have to get powers of sale for those. So it's a really complicated situation, even though I think being an early crypto platform, it should be a little bit more simple, you'd think, because it was a bit more simple than I think in terms of some of the types of contracts and things that people were entering into. But yeah,
and that's actually quite a good segue to our next point, which is, Chris, that one of the things you had to grapple with as well on 3AC has been realizing, and not just on 3AC, I think other situations as well, is realizing, you know, what we call less liquid assets. Do you want to give a little bit of colour about why that's a particular issue for crypto insolvencies, and yeah, potentially, I suppose, an opportunity for people on the other side of transactions?
Yeah, look, I mean, I could honestly talk about this all day, but I'll try and keep it relatively brief. The issue with crypto is, and we've touched on this at the beginning, so custody is a big thing with crypto. Custody of the ability to better actually custody different types of crypto. So there is technically a difference between a coin and a token. We'll go into the sort of semantics of it, but there are also different layers of token that are available out there. And not every custodian has the infrastructure to be able to support said token. So you're looking at custody either in an institutional sense, or you're looking at self-custody. You've got issues then with, you know, the risk of hacking. You've got lack of insurance, etc. You know, in terms of when we're looking at an asset pool, liquid assets, we are talking about something that can effectively be custodied in some form or manner, be that through an institutional custodian, some form of, you know, third-party custodian, or self-custody that has a existing market, and the token or the coin itself is not subject to any contractual restriction. And when I say contractual restriction, there's two types of effectively what's referred to as lockups on tokens. So when an issuer issues a token, you may get in on a seed round or a private round. You'll buy into what's called a simple agreement for a future token, or there may be a simple agreement for future equity with a side letter or a token warrant, etc. Once that warrant or that token issuance or the token agreement is executed, there's a period of time between then and what's referred to as a token genesis event or token generation event. Upon the token generation event, the token that's being issued that you effectively bought a right to, contractual right to, is then issued on chain, on mainnet. Those tokens are then held by the issuer or by an institutional custodian, most often now by institutional custodians, subject to what's called lockup or vesting periods. And the reason for those vesting or lockup periods is simply that otherwise, if there are a billion tokens that were being issued on the Monday, a billion tokens can be dumped onto the market immediately by the sellers. So it sucks all of the liquidity out of the market. Obviously, there's going to be no value left in the token unless you're looking at, there's a potential for an extreme downfall in value there. So when we refer to liquid tokens, it's anything that is held by the estate that's not subject to those types of contractual or restrictions. And in lockup as well, it's interesting because there's two ways of locking up a crypto token. You can do it via a smart contract, which is automated, or you can do it manually via an institutional custodian, effectively running an internal ledger. So the latter is very analogous to, for example, the internal bookkeeping of an exchange, whereby everything is done via an internal ledger if there's not a segregated account for each of the customer's asset pool or crypto. Whereas the other is the automated, which is a smart contract that you can go and read online. It uses Unix, which is a type of code, and time value on code, etc. That allows you, as the owner or as the owner of the contractual rights to those tokens, to go and investigate when the vesting period and the drop dates, etc. of those tokens. So that's really what we mean by when we say liquid and illiquid. There's also another category, illiquid tokens, in the sense of something you simply cannot sell because it's subject to some form of contractual restriction or consent, etc.
And why do they need to be treated? But I guess why do they need to be treated differently for a liquidator? I guess your concern, right, is you've got a duty to realise these assets, but at the same time you don't want to destroy their value. And that's the challenge.
Yeah, absolutely. That's exactly the point. I mean, our job is not to speculate in terms of the value of an asset. We keep going back to this point, protect, secured, and distributed creditors. But with the volatility, and with the restrictions that are attached to a lot of these contracts and these tokens, there's basically nothing you can do with a lot of these, unless you get consent of the issuer, which it has been given, and we are constantly in discussions with counterparties and third-party issuers and protocols, etc., to discuss with them the best way to effectively realise value for the token. Now, when we were first appointed, we go back to the crypto winter, so we're looking at the prices, as we said, had dropped to such a value that everybody was looking at liquidation in a fire sale sense. So even anything that didn't have a spot market, i.e. anything you couldn't trade out via a liquidity provider, and for that purpose as well, and that kind of segues into we as liquidators have to have liquidity options, so we have to use brokers, we have to have OTC agents, either be it agents or principal desks, etc. That's a whole other world that we have to kind of invest into and become part of the infrastructure of. But going back to the point around the counterparties, we're very conscious of ensuring that we maintain value in the tokens that we hold for the creditors of the estate. So entering into an agreement where, just for argument's sake, someone's offering us 40% of the value of the token that unlocks in 6 months and then unlocks over a period, over that period of 6 months, is not necessarily representative of the value. By that same token, at the same time, we communicate and discuss with our creditors committee, who are very active on the 3AC case, and who are all major players in the crypto industry, to discuss what the best strategy would be for terms of realising value on these tokens. And the third limb of that, as you touched on there, Tim, was really those discussions with the counterparties, because we're very conscious of ensuring that we maintain the value and the relationships that we have with these counterparties, because crypto is still a very small industry, still in its nascent stages, and a lot of these protocols are relying upon the good actors, as it were, and people not taking actions that are against contractual rights built into the tokens to ensure that they maintain value once they're issued.
Louise, now you're back with us. Hopefully the tech's working. So you're very involved in the thought leadership of policy community on digital assets through your work generally. How do you foresee the legal landscape changing in ways that might be relevant next time? And there's a failure in the digital asset space. I think you're on mute. Louise,
If I start, I should just say I am happy.
There we go. We can hear you now.
Still can't hear me. Can you hear me now? Good.
I can hear you now.
If things start getting odd, I'm going to turn my camera off. I'm just warning everybody because the internet here seems more dodgy than I thought it was. Okay, so you're basically saying what's going to happen in the future, or what issues are there still to. First question really is legal certainty. Where is this going to come from? And in the future, in the near future, and to some extent the more distant future, this will come. In many jurisdictions, it will come from the courts. So the sort of things that you're talking about, the sorts of cases you're talking about, the courts will be able to refine the applicable law. Many jurisdictions will also want to legislate, and I think there is a real issue about what kind of legislation we should have. Can you still hear me? Yes. What kind of legislation we should have, and I should just mention that in the UK, as I'm sure many people are aware, the Law Commission in the London world has been suggesting a very minimal approach in legislation and allowing the case law to develop all of that. So that's a sort of process point. The future areas, which certainly are going to need more development, I think one of them is course regulation, which I'm not going to talk about. Another is what we in the Digital Assets and part of a project have called linked assets. In other words, where you have a crypto token that is linked to another asset, either a tangible or an intangible, such as a security or as a right or something like that. And what we did with the principles was to say that although this is a kind of an analytical way of looking at it, the actual way in which such an asset can be linked to a crypto token is going to be a matter of domestic law. And so we're looking at developments in domestic law in that area. It's not something that one can completely generalise about. But I would mention that the UK JT Task Force has been looking at this in relation to securities, for example, and we quite important in the future, as to see what you have when you have a security that's linked to a digital asset, or you have a payment right that's linked to a digital asset, and that might, in English law now, fall within the Illicit Trade Documents Act, for example. Then another area which is getting a great deal of attention at the moment is digital assets and private international law, conflict of laws. Applicable law, what law is applicable, and as probably many people are aware, the Law Commission has issued a call for evidence in this area, but there's also some work's been done already at the international plane because of the digital assets private law as a principle on private international law, that it was never designed to be complete, and more work would need to be done in that area, and there's still consideration going on in that area. And then the last area that I mentioned, which I think has come across greatly in this seminar, is enforcement. What do you do about enforcing? What do you do on insolvency, but what do you do outside insolvency as well in tracing digital assets, getting orders against them, and so on. And this is an area that we didn't go into great detail in the principles because it seemed very law jurisdiction specific. But there is, UNITRA's working on a project of best practices in enforcement, and that's looking specifically at enforcement in relation to digital assets, and some of the questions you've already mentioned are being looked at in some detail. I'll come back now and see if you can still hear me.
We can see you again, and thank you very much for that, Louise. So we'll now move to Q&A, and we've had a question come in for digital assets, and neither things in possession nor things in action, but a new third category of thing. Shall I venture an answer on that, and then Louise can tell me why I'm wrong? So I think that William Blackstone, when he devised that distinction between shows in possession and shows in action, I don't think it really has in mind the idea that these are the only kinds of things that could possibly exist and that English law can recognise and deal with. I think the concept of shows in action actually is much broader than that. If one looks at the underlying text, so I think it's probably always been the case that digital assets would be treated as probably shows in action rather than shows in possession, because it's difficult to have physical possession of an intangible object. But that being said, I do think it's very helpful for the Law Commission and for legal systems generally to clarify the status of digital assets and other forms of intangible property, in just the same way as we have special laws that deal with securities, special laws that deal with intellectual property. It makes sense to ensure that there's a legal framework that's tailored to the particular challenges that digital assets present and the particular opportunities that they give rise to. Louise, what have I missed?
I would very much like to come in on this. I think it's a really good question, but a very important point. I basically agree with Tim, but I think that rather than saying we need a specific regime for digital assets in terms of type of property, I'm a great supporter of the Law Commission's view of other intangible property. In other words, neither of the above. So it's in a sort of residual category rather than having different categories. If you look at some of the other common law jurisdictions that have statutes to do with, say, secure transactions, they try and say, right, we have lots and lots of different types of property, and we have to put everything in different pigeonholes, and that just causes all kinds of difficulties. Yeah. It seems to me, though I know people don't agree with me, very clear that digital assets are not chosen action because they aren't, at least not the crypto assets we've been talking about, because they don't exemplify a right against another specific person, and they're not chosen possession, despite the fact they have many things in common. And so it makes every sense to have a third category. And I would just add that there are other things around that will also can also fall into this third category. And one of them is something I'm doing quite a lot of work on at the moment with UNITRA, which is carbon credits, particularly carbon credits in the voluntary market. And they don't fit very nicely into either of the categories, but they would fit very happily into a residual category as well, and they're also pretty important things.
Donna, I think a question for you. Sorry, thank you very much for that, Louise.
I saw that.
Donna, a question for you. I've come across the issue of change in terms and conditions in another context. Where's the burden of proof? Does the platform, I guess in this case, the liquidator, have to prove that it's been clicked?
It's really interesting. I think in Gatecoin, it was actually the way the court put the test was really for the customer to show that they hadn't clicked. Now, I agree. I mean, that is really, really hard. Proving a negative is incredibly difficult. And also in the case of an insolvency, often you don't have all the books and records, and you don't have, in our case, the platform wasn't running. It was long gone, if you know what I mean. So what we had, in our case at least, I thought we acted very reasonably. The liquidators looked at the ledger and to see if anyone had done any trades after the date of the new terms and conditions, the one saying no trust. So if they were trading after that time, prima facie, they've gone onto the platform and they've clicked. And in our case as well, Gatecoin didn't have a physical presence. You couldn't just walk in and do it. You had to do things online. So that prima facie assumption that someone has clicked, I think, is fair. And so we said, right, rather than putting all the customers to the effort and this dragging on, the liquidators made a decision, said to all the people who had trades after that date, you're prima facie, you've consented to the change. And that's when we got back these responses, which is what we wanted, of certain customers saying, well, wait a minute, that trade was done OTC. I did it over the phone. It turns out there was some OTC trading, not using the platform, which we didn't know about. And they had proof of that, so they're good. And then there were other customers saying that Bitcoin came in as a result of a mining contract that I'd signed 2 years before. I didn't click. So some people can prove they didn't click, but it really is going to be a case by case. So it's time consuming. It has to be done because it's trust. If someone's got a trust, they've got a trust. So you have to respect that.
Great question. And the last question, maybe this is really one for you, Chris. So you've been appointed as an officer of a crypto platform, and it's starting to face distress. What practical steps would you advise an officer, I guess, a director of that company to take?
I mean, in terms of, if you're looking at a director, so obviously the ongoing fiduciary duty, seek advice as soon as possible. Certainly do not bury your head in the sand and wait for the market to pick back up. Because again, given the volatility in the analogy I used earlier, it goes upstairs, down an elevator. It could be over tomorrow. So seeking advice as soon as possible, and advice from persons who are experienced in dealing with digital assets, because it is still, and I've referred to this previously, it's a nascent industry. There's a lot of people who are sort of aware broadly of Web3, crypto, decentralized, centralized entities, etc. But having an actual full understanding of the ins and outs of it, there's a lot of practical experience that comes to the likes of the engagements that we're all involved in, and that builds a lot of knowledge base, and we can see analogies between some of the cases that we deal with and inquiries that come into us, and we can add a lot of experience and really preserve value, and that's where it comes with the liquidation position. So we have a institutional custodian that we utilise. We have actually a number of custodians we have access to. To Louise's point around on-chain tracing, we have relationships with on-chain tracing. We have proprietary tool access. We use we use wallet profilers. We're utilising third parties who assist us, for example, with the NFT airdrops and other types of sort of nuances of dealing with Web3 and crypto. There's a huge amount there in terms of knowledge base that's been built up by experience. And I think one of the things that we spoke about previously on this panel, one thing I wanted to get in was that we talk about this the spring and the summer of the crypto world, right? So in contrast to the bear that normally hibernates in the winter, we're looking at a bear that's hibernating through the summer or the spring and the summer. And we're going to see, the next crypto crash that we see will likely make the likes of FTX and Celsius and other crypto crashes that's relatively small in comparison. We're already seeing Bitcoin above $70,000. We're already seeing the crypto market hitting above $3 trillion in value. So what does that look like at the end of this next, whatever you want to call it, super cycle? And fraud is as old as time itself. And unfortunately, with crypto and sort of lack of I listened to the panel yesterday on regulation, and one of the issues is obviously state, federal. You've got the same thing with MICA in the and in Europe. You've got an extra number of jurisdictions with we're sort of trying to chew on in one regulatory regime, etc. There are always going to be episodes of things like rug pulls and hacks, and it's just part of the course with we're dealing with the crypto industry. So I think just keeping an eye on it, being aware of, listening to panels like this, speaking to experts in our industry, and that goes both ways. For us, we also need to be out there speaking to those who are participating in the Web3 world, attending conferences like Consensus, etc., and speaking to people who are actually at the coalface of this, because they're ultimately the ones who are driving this technology forwards. And we need to be able to, as professionals, we need to understand what the next advances are to be able to get ahead of it for what will be the next bear cycle, or when the bear decides to come out of its hibernation.
When the bear decides to come out of hibernation, yeah, and indeed, just because it's good times for most people doesn't mean it's good times for you. So I think your advice to act early is exactly a sentiment that we would share. So Dara nodding. Very much what we would see in practice. Okay, well, thank you very much, everyone, for your time. Thank you, Louise, Chris, and Donna, for being excellent panelists, and for everyone who's joined us on the line. We'll call an end to the session there. But we're very grateful again, and we hope it's been interesting and enjoyable for everyone who's able to join us. Thank you so much.